Hello, everyone. Let me introduce the first Fireside Chat, and we're talking about the protection of information policy, the POPI law, which is going to be, applied, and we will be looking at how, as a company, you have to deal with the most basic issues. We will, in the future, also drill down into specific issues, but for the moment, this is the introduction to the whole issue. And I'm joined today by Warrick from Insaka E-Commerce Academy. He will be asking the questions and driving it forward by Rieka van der Beek, who is the chair of our legal and representational committee at the e-commerce forum South Africa, and Thomas Reisenberger, who is from Legalese and is our lawyer and trusted expert on anything to do with law. So with no more ado, let's get going. Pass you over to Warrick. Warrick, please start on the questions.
Thank you, Alastair, for that great introduction and for organizing this talk today. I think it's so crucial and important that we have these discussions to understand what is POPI or the POPI Act or POPIA. What is it all about? What does it mean? What do business owners need to know and need to change in their business? And it's some serious stuff. You know, it's been in the wings for a while. Now it's coming to the fore and we need to know what we're doing. So thankfully, we've got these experts here today. And I think we should just kick it off with a simple question of what is POPIA? Like, where are we going here?
Absolutely. Warrick, I'm going to jump in here for this one. Morning, everyone. And thank you for allowing us to be involved in this amazing discussion. Warrick, best place to start. They always say every journey starts with a step. So, of course, what is POPI, POPIA? I love all the different pronunciations. In short, guys, it is the main data protection act that is now going to be facing South African citizens and people that are processing data through the borders of the Republic of the country. And what that means is that if you are processing people's personal information, whether for your own purposes or maybe someone else's purposes, we have now reached the stage where we realize the amazing value and risk associated to a lot of this data being proliferated around the world. And we've gotten to the stage where we recognize that it needs to be protected. So what we've done in South Africa is that even from 2013, when the POPI Act was officially drafted, it's been that many years, we have now gotten to the stage of fruition. So with the advent of the POPI Act, which is going to be discussing this in a few minutes, is when does it come into force, but it is coming around the corner. It means that South Africa now, if you're processing data within the country, you will need to apply the Act to all of your processing functions. And also important to understand is it's quite a big mindset shift. This isn't a simple little change of regulation. It's not a simple little tweak here or there. It's really quite a big mindset shift as to how we understand data, how we value data, and really change the way we do things with it. Because we now understand that it's really an asset, like you would have money from a client or assets given to you by a client. Data must be seen to be that sort of thing as well. So POPI has come in with that mentality and that understanding, and that motivation is to protect that data being processed by people within South Africa.
And also just to step in there, Thomas, one thing, what is the difference between data and the personal information? So how can I draw the distinction between the two?
That's a very, very good point, because of course, data can include everything. It can include descriptions of things, metadata, bits and pieces. What we're mainly focusing on and what the focus of the Act really is about is something called personally identifiable information. It's information that is linked to people. And interestingly, in South Africa, it's not just natural persons, but also companies, which is slightly different, for example, to the EU, where they just recognize natural persons' information. But the focus is on information that can be reasonably linked back to an individual to be able to identify them. Because, of course, some information may be explicitly identifiable to a person, right? The name, the surname, the ID number, that's quite clear. But what may be a bit unclear is that there are many other types of information out there where, with a little bit of discovery or a little bit of investigation, can quite easily identify somebody. So it's not just simply name, surname, ID number. It could also be opinions expressed by someone. It could be a political affiliation or someone's race or even medical information. So the way that it's defined in the Act, they have given you a set list of what they consider to be personally identifiable information. But what they do is they also recognize the fact it's not a closed list. They say including but not limited to. So it is a common sense approach, and it's not just what they list as personally identifiable information that will be the focus of POPI, but it's also up to you and I to also think about the data we're handling and think, can this reasonably be linked back to someone? Of course, with a lot of technology, you can make almost any information personally identifiable, but that's not the approach we're taking with the Act. It's a reasonable common sense approach to protect the data that is linked to a person or a company, because that's an asset for them.
So just to jump in there, I think it's very important in terms of e-commerce, whether you are B2B or B2C, you are dealing with personal data. So if you are B2B even, you're dealing with the name of the salesman who you've had contact with, the people who are buying from your website, etc. So anything you're collecting and then storing, which of course you do, in order to ensure that that person's getting the order that they've made, is part of this whole process of protection of personal information. Sorry, just to make it clear.
No, and that's a perfect segue into really just bringing us back to e-commerce, into online selling. Like from an online seller's point of view, what do we need to be knowing about and need to be actioning right now in terms of POPIA, the POPI Act, or whatever you want to refer to it as?
I think the first question you have to decide, Thomas, you will definitely speak about the legal aspect, is what you want to call it. So you've got to pick your name. Is it going to be POPI, POPIA? Stick with it and go with it. But I think, first of all, you have to then start looking at what you need as a business to operate. So what categories of personal information do you really need in order to supply your goods? Bring it to people. So you start with that aspect in mind. That's the first point. And then the next point is to think about your actual website, how you're gathering the information, where you're collecting it from, and where you're keeping it. Try to keep it in a safer location, not on, let's say, your desktop or on your phone that can be easily accessible. So those are the first tips that I can come up with. But Thomas, you can step in as well. I'm sure there's a structured task way that lawyers best describe it.
Yes, I think that what I'm going to do is, I think I've kind of, after what are we dealing with, almost 8 years now, having to deal with this act as well as experience with GDPR, what I've managed to do is I've percolated down the whole act, which is easy to read, by the way. So I fully support that everyone must go and read it, definitely. But what I found though with the act is it's quite ethereal, it's quite intangible. There's not much of a huge practical focus. So what I've managed to percolate down from having read the act and dealing with this in practice is I want people with e-commerce stores to think about total compliance as 3 separate major legs. Okay, so when we're talking generality, I want you to kind of summarize it like those 3 big legs. And what are these legs? The first one is having an outward-facing privacy policy. Very, very important, guys. This is probably one of your most priority items. And also because it's the fact that it's generally inexpensive to draft. So please don't be worried if you're bootstrapping, you're running your store, you just launched something. It's an absolutely essential item, and it's not that expensive to draft and not that difficult to do. Of course, it must obviously be bespoke to your company. Do not copy and paste someone else's, because of course that speaks to their processing. So you must, obviously, you can start on a template, definitely, but it must be comprehensive and tailored to your exact processing needs. Okay, so that's leg 1, privacy policy. The second leg is what I call the actions. It's not what the act calls it, it's what I call it. It's the internal systemic handling requirements of data at your company. So there are quite a few number of internal things that you are going to need to have. You're going to end up with quite a few internal policies, like having a data flow map or having a privacy impact assessment if you're required to have one. So these are quite a few of these little policies, as well as other actions that you need to do. Training your staff, updating employment agreements or service contracts with data clauses. Now, guys, this leg 2, the actions, is quite a laborious process, but it's primarily internal, which means that no one from the outside world sees it. Of course, you know, God forbid something goes wrong and they need to check things, but these items in the background, they can take a few weeks to do. It's not complex, it's just laborious. So what I always say to my clients, and especially for e-commerce stores, get going on these internal things sooner rather than later, okay? And then the last aspect, the last leg is what I call implementation. which is every one of your e-commerce store customers, or anyone actually, has many avenues for how they receive data, right? They're getting it via the website. They're getting it from telephone calls. Heck, they're even getting it from people stopping you in the street and handing you a business card. Now, in all of those avenues, you're receiving data. And what you must then do is make sure that for each of these onboarding avenues, you have the correct process implemented. So on your website, you may need to have that cookies pop-up banner that you see come up often on websites. You're going to have to make your privacy policy available, and you need to warn people at salient junctures where you're taking their data, that you are taking their data and the application of the privacy policy. So those, if you can kind of sum up the main, how would I say, focus of trying to complete compliance for POPI, is dealing with these three legs. And as a priority, it's certainly the privacy policy and implementation, I would say first, because it's the public-facing aspects of how your company is compliant. But of course, you have to be doing the internal actions. Otherwise, you're essentially lying when you hold out your privacy policy and you say that you're doing these things, but you don't have them internally. So Warrick, just as a summary, I find that those three legs are a nice sort of summary to understand it and to make it a lot more practical and tangible to people. And the other thing, I'll get into specificities now, but one thing to also remember is that you do not get any sort of certificate of compliance once you become POPI compliant. I think there's a lot of confusion. You know, they think that, I'm POPI compliant, someone gives me a certificate, I can stick it on my wall and I can hold that certificate out to people. That's not the case. It's very much self-regulation. So it's really an onus on you to make sure that you're doing everything correctly. Warrick, just to your points on what I think are probably the most important facets for e-commerce stores to be thinking about right now, let's make a note about these things. The first thing is, please make sure that your actual engineering of your data storage and security is up to scratch, okay? The issue with POPI is it doesn't really prescribe exact standards for security and storage. It says reasonable industry standards. It tells you to look around at what's available in the industry, and according to the company nature that you are and the resources that you have, and implement those things accordingly. So please, as a priority, you need to get your data security and storage up to scratch. Very important. The second thing which is important is to make sure that all of your public-facing documents talking about your compliance are also perfect. Like we said, your privacy policy and implementation. Why? That is how your company is represented to the world. And if you don't espouse that sort of professionalism, especially dealing with intangible websites, you know, gone are the days where you go and kick the tire and speak to the salesman, where you can really test the mettle of this company. Now you have to be able to espouse that professionalism online. So make sure that your public-facing POPI compliance elements are perfect, because that's how they're going to regard your regard for their data, which of course must be paramount. And the last thing I want to also make mention, and Rieka and I were discussing this yesterday, which is, guys, if you want to stay attractive in the e-commerce world and you want to continue to be able to deal with other companies and your clients, you must become POPI compliant, because you need to stay within their data chain. Meaning that if someone is POPI compliant, they cannot hand you their data unless you are also POPI compliant or have standards that are equal to or better than that. So if you don't get POPI compliant, what starts to happen is that you're going to notice your clients are going to start disappearing. You're going to notice that some of your service providers are going to start disappearing. Why? Because you are not POPI compliant, and therefore they can no longer do business with you once they get POPI compliant. So to stay attractive in all of those data chains, guys, please make sure that you are staying compliant and that you certainly have agreements with everybody in your chain. You can no longer accept data willy-nilly and give data out willy-nilly. When you receive data and when you provide data, there must be a contractual basis for that provision or receipt. Okay, so those are my real big focuses for e-commerce stores.
It's so interesting. And, you know, for an online business owner, there's no shortage of things to do. And now this is something else that we need to be on top of, and we've got to get it right, because heck, if we don't get it right, there's a lot of problems that could come up for us, which will be in part 2. Stay tuned. But the thing that's coming up for me is just like when you say that we need to get this drawn up, like our privacy policy, I've always told our students, you can't not have that. And it goes also to building trust with your customers. If you don't have that, they're not going to shop with you. They need to see this for trust. But is this something that an online business owner will need to engage with a lawyer to get done correctly? Or is it possible to read the POPI Act and just update our privacy policies ourselves?
I'm going to have to say this, and this is one of the things we're kind of proud of at Legalese, is there's certainly no need to pay a lawyer to do something that you can do yourself. Take a little proviso. I'm going to add that on there for a second. But what I need to mention is, guys, like any contract that exists on this planet, it is a bespoke agreement between two people. It's about managing a relationship. What I actually find a lot of the time is that lawyers tend to obfuscate that relationship. They confuse it. They make it too complex. So what I would suggest is, certainly you can make an attempt at doing that privacy policy yourself. Okay, definitely. For two reasons. Number one, it'll save you a heck of a lot of money to at least get the ball rolling on something. And number two, it's about education and self-empowerment. The problem with simply handing a contract over or to deal with POPI compliance to an attorney is that you as the e-commerce owner will not learn the benefit and learn the understanding and the needs and the requirements of POPI and data protection for your company. Just like you need to know a little bit about accounting, and you need to know a little bit about dev, and you need to know about, every aspect of your company, you are certainly going to have to know about data protection too. So as a start, certainly you can definitely get either a template or you can start drafting one on your own. What you can also do is look at other people's privacy policies for inspiration. But hey, guys, do not copy and paste, because number one, that's someone's intellectual property. And of course, it's a bespoke document for them, which is not going to match your processing. So make a start yourself, because it will get the ball rolling and maybe even make it cheaper later. But what I would then suggest is, before you launch it and you make it public, there is certainly a benefit in maybe getting a professional to look over it, because of the fact that they're not having to draft from scratch. So it'll be certainly cheaper to simply review and conduct an update. Okay, so definitely. And again, also, it's a time consideration. We've got maybe 2 months left. You guys also have to decide, as an owner of a store, do you have the time and money to be able to do this yourself, or is it actually worthwhile to simply hand this off to someone to do, recognizing that you should never just defer everything. You must still have a handle on it yourself.
Absolutely. And you mentioned that there's 2 months left, and whenever somebody's watching this video, maybe the date has gone past, maybe it's still looming, but we have certain deadlines that are approaching us right now. We're recording this beginning of May 2021, and that POPI Act is now coming into play very soon. So what are the specific deadlines that business owners need to have this all in place by?
Very, very good question. And this has been kind of a moving goalpost for so many years. I think that people almost got tired of, when is this actually going to become a law? Guys, it became formally law on 1 July last year, but we had a grace period allowed to us by the president as part of the act for a 1-year period, which means that by the 31st of June this year, 12 o'clock at night, you need to be fully compliant. So come 12 in the morning on 1st of July, you need to be fully compliant. The only other date, which is also important to remember and to recognize, and we will be speaking about this aspect in another little piece of engagement we will be sending out, is something called the Information Officer Registration. This is the only other time that you guys should be taking note of, because of the fact that the due date is 1 May. So that maybe for some of you, it may be right now, the time may have passed, but what is that date? Is the Information Officer, which is the person that you need to delegate at your company to be in charge of data at your organization. They need to be formally registered with the information regulator, who's the authority in charge of POPI and data protection in the country. You must register your information officer with them by the 1st of May. Now, of course, this has been quite a short timeline. How do you do it? You simply complete the form, which is available on the website, and submit it to an email address. That being said, the information regulator is in the process now of finalizing a portal, which will actually automate all of this. So you won't have to complete a form. You will simply go onto their portal and action your registration there. But please go take a look at the information regulator's website when you watch this and see what stage they're at. Maybe the portal is there. Otherwise, you may have to complete the form. But what we're looking at, 1st of May for information registration, information officer registration, and then 1st of July, you need to be up and ready.
Excellent, excellent. And Alastair, I hope if you wouldn't mind making a note just to put the link that Thomas has been referring to beneath this video for anybody who needs to do this. I know certainly I'm feeling a bit of that anxiety building up, because we haven't done this, but I got time, so still going to get this done, just like so many other people still need to do. But Rieka, I wanted to ask you quickly, there's a manual that we need to have in place, or do we need to have that in place, and what's the deadline for that one?
The POPIA manual. So I think we're actually going to discuss that in a little bit more detail, because there's different thresholds of which entities need to actually have a POPIA manual. So it depends on the size of the organization. So that's the first thing. So don't be too scared as your e-commerce shop that you might actually have to have it. But what I actually wanted to touch upon before we go to the POPIA manual is when you are drafting your own privacy statement, there's a benefit to why you're doing that. It actually helps you, in addition to learning how the process works, you start to identify what processing activities you're doing, what your organization is actually receiving and collecting. And that actually helps you streamline what you should be getting, what you don't need anymore. And then what that means in the end is you can keep it up to date yourself. You don't need to get a lawyer to keep it up to date, because you've actually learned, I know what's in my policy, I know what I'm telling people, and I can actually handle this on my own. So I just wanted to flag that as quite an important aspect. The privacy policy and statement is a living document. As you get new clients or new processing activities, you get a new method of collection, just add it in. There's no reason to be scared to do that. You're actually encouraged to be transparent in that perspective.
Absolutely. And this ultimately, while it sounds like a lot of work, and it's just adding another thing to our to-do list, and ultimately it is a good thing. Those phone calls that you get from the salespeople and those SMSs that just come in about all these old relatives of yours that have been dying all the time and leaving you money. Well, that should start going away. And personally, I know that I like my privacy to be protected, and I'm sure everybody here would agree with me. This is what the government is putting in place to make that happen. And so it is ultimately a good thing. We just need to make sure that we are compliant. And in part 2 of this video, which will be linked up beneath this video, then you can join us again for part 2, where we're going to continue this conversation and dive deeper into the other topics, what you need to do, how you're going to do it, and just unpack a little bit more about what you need to know about POPI. So we'll see you now in the second video. Scroll down, get that link for that one. We'll see you there right now.
Welcome back to this session on the POPIA, the Protection of Personal Information Act, which is being applied in South Africa at the moment. We have here the experts in this Fireside Chat. Most of you, I hope, will have seen the introduction. One point that came out of the introduction was a point made by Warrick, a most important point, which is trust, and the whole issue of ensuring that your consumers, your buyers, the people who are your clients, trust you. And I think data protection and data use is something which we will be looking at as an instrument of ensuring trust. So Warrick, over to you, please, sir.
Thank you, Alastair. And we've just wrapped up part 1. So if you haven't seen part 1 yet, please do look beneath this video for that link. Go and watch that one, and then come and watch this, which is part 2 of 2, where we're now diving into like the practical stuff. Like, what do we need to know and do actually to get our websites and our e-commerce businesses compliant for the POPI Act? And I suppose one thing that comes up for me is about this cookie banner. We've been seeing it popping up more and more frequently on sites, and especially when you're on mobile, you open a site, the whole screen gets taken up by this cookie banner. Do you accept it? Do you not want to accept it? I don't even know what it means. Like, I think consumers will become educated, but one thing's for sure is that I know that it hurts people's conversion rates. Like, that banner's hurting your sales. That'll also go away over time. But in the meantime, like right now, with the deadline around POPIA Act becoming necessary for us all to be compliant, do we have to have that banner in place, or is there a way around it?
Yeah, Warrick, let me jump in here on this. What I find is one must look at it with a practical perspective. And what I say to my clients is, remember what this pop-up banner does and what your privacy policy does and all of these sorts of warnings around your processing of people's information is, guys, you are in essence providing your data subject with a contract, where you're telling them the features of how you will be providing the service. What is the service? It's the processing of personal information. And you have to notify the person about the service that you're performing, and give them the opportunity to understand what the terms of that service are. So what that means for your website is, if someone lands on your website and your back end, your technology, the systems that you're using, the software has already started processing their personal information, it means that you need to immediately notify them about the nature of that process. So You may be thinking, but hold on a second, they just landed on the page. How am I processing their personal information? Remember, guys, technical information can also be considered personally identifiable information, which means that if you're processing any sort of IP addresses, you're building cache, you are putting cookies down, that is technical information that is considered personally identifiable information, and you are processing it from the second the person lands on your page. Now, they haven't formally signed up for your business or your services yet. They haven't clicked your terms and conditions. They haven't even registered their profile yet. So they haven't had an opportunity to be made aware that you are processing their data. So that is the motivation and the reasoning for having that pop-up banner. Is that pop-up banner has to happen the moment they land on the site. Because what is that pop-up banner doing? It's making them aware. It pops up and it warns the person, I have already started processing your data. What is it? It's merely cookies for now and other technical information, but you're in that pop-up banner, you are also going to make the privacy policy available via hyperlink. So if someone wants to go and see how that privacy policy or how those cookies are working, they can go do so. So the motivation for having the pop-up banner is, guys, if you are indeed processing technical information, and that's the first thing to start asking, because some of you may not be processing technical data. Some of our clients don't do that intentionally. They wait for a formal sign-up. But if you are processing technical data, you need that pop-up banner to arrive and warn people in the proper wording saying, by continuing the use of our website, we are processing your personal information in accordance with our privacy policy, and you make that available via hyperlink. And then to get rid of that warning, there's that little OK or accept button. There is a bit of debate, and Rieka can maybe lean in on this if she wants to, but there is a bit of debate on, does that pop-up banner need to stay there until they push accept or OK, or does it need to block the use of the website entirely? And from what I've seen in practice, and unfortunately, because POPI is so young, we haven't got practical guidance on this. So we do look to the EU model quite a bit. But what I can say as a fail-safe is, guys, if you are processing the technical data on landing and you do have to provide the pop-up banner, please make sure that that banner does not go anywhere until the person has pushed the accept button. You do not need to block their functionality of the website, but do not allow that warning to go anywhere until they've pushed that accept. Okay, again, that is still up for a bit of debate, and I think that that will be developed as POPI's practical guidelines get developed. That may change a little bit in practice, but the reasoning is you've landed, you're processing, and accordingly you need to warn people that you're processing already from that first landing juncture.
And here I would say definitely the actual, wall, cookie walls, I think is when you actually can't see anything at all. It has been basically in the UK and in the EU said that that's not a practical way of doing it, because essentially you're forcing individuals to have to, first of all, read this before they can even start engaging with the website. So it's not a genuine acknowledgement and understanding by the visitors of the site. So first of all, block out full banners across the whole is really not needed. It harms the journey of the user and is not practical. What is a good idea here, I don't think there's the same requirements as in the EU under GDPR, well, actually the e-privacy law, where you have to specify each and every cookie. But what you can do is have a banner saying this is a privacy statement, it includes cookies, and in your privacy statement, you tell them what types of cookies there are, and then in fact, where they can go into their browser to disable them. So a quick link to how you can disable them on Google. There's available online. There's also free Cookiepedia that you can use, and those type of tools, and just add them into your privacy statement. And at least then you've done the education for your visitors who are coming to the site.
That's a great addition there, and thanks for that. At the end of part one, I ended off by saying that this is a good thing. This helps protect our privacy. But when I put on my online seller's hat and I start to think about the limitations of this, firstly, if we had that cookie wall where somebody couldn't use our website, that would be a disaster. So now they put it at the bottom, and when people are on mobile, it becomes a cookie wall most of the time. But I think what we also need to talk about here is, like, how does this affect our marketing? Because now this could be affecting our conversion rate with people just getting onto the site and seeing the site. But people, when you're saying that, are you tracking their details? And a lot of website owners would be like, well, I'm not yet, until people sign up for my email or they start checking out. But that's not entirely true, because what about Google Analytics? You're recording their data, where they are, where they came from. What about your Facebook pixel that lets you retarget them? And how is that all affected by this cookie? Like, Thomas, if people don't accept the POPI banner on our website, does that mean that we can't advertise to them through remarketing or know the details about them through Google Analytics?
It's a very, very good question. It's a very much a balanced approach here because of the fact that ultimately, and this is, I want you to think about this as the kind of the main overarching statement, which is that, guys, your ability and your right to process people's personal information is based on a lawful ground to do so. Okay, so what that means is that under the Act, they've identified that there are various lawful grounds to process people's personal information, one of which is consent. You also have two other major grounds upon which you can lawfully process people's personal information. One of the other ones, which is going to speak exactly to your point now, which is pursuant to a contract of service, right? Which means that effectively I'm providing you a service, whether it's written down or not, but I'm providing you a service. And in essence, I need your data in order to provide you with that service. It makes sense. How am I supposed to deliver the goods to your house unless you give me your address, right? So I don't actually need your consent in order to process that personal information if it is pursuant to a contract of service that I have with you. Okay, so that may definitely work as a solution for your situation in that you may be able to certainly continue to process people's personal information, notwithstanding the fact that they haven't given you that consent, as long as you do have an existing contract of service with them. But now, Warrick, you're going to say, but hold on a second, it's the first time they've ever met me. We don't have a contract of service in place. In which case, then you may be able to rely on the third ground, which is pursuant to legitimate business interests. Now, this is a bit of a catch-all, and as a lawyer, I always hate these very open-ended grounds because what is a legitimate business interest? Can you see already? You like this one? Because I can, as a business owner, I can legitimize anything. Any data uses, well, it's legitimate to my company. Obviously, we have to stay within the realms of reasonability and logic. But what you can then say is, I need to possibly continue to process maybe restricted metadata or some basic information from that individual because it's legitimate to the business that I'm running. It's to be able to engage with the person properly on the website. It's to be able to deliver them a certain access on the website or something like that. So using the other two remaining grounds when consent is not available is certainly still a way for you to continue to process data. But at the earliest possible convenience that you can, I would then get express informed consent if you can, because that is the gold standard. And that way it's undeniable that you may process people's personal information. Okay, so in a situation like that, the person doesn't want to accept it or something like that, there are other grounds that you can legally rely on. So you're not going to, no cops are kicking down doors just as yet. There are some other avenues available, but you must remember, guys, it is a valuable asset that you're now taking from people. And accordingly, you must treat it as such. So we must make sure that the earliest opportunity we do receive a full consent. Okay, so don't simply brush aside consent and think, oh, no, man, I don't have to provide the privacy policy at all. I can rely on something else. That'll only work for sometimes. And the best thing to do is obviously get the consent when you can.
And so that begs a question. And I think that just for the sake of clarity, this question needs to be asked. When POPI comes into full force, 1st of July, 2021, does every single website in South Africa that's collecting information need to have a cookie banner?
I would step back a little bit and I'd say everyone needs to be compliant. Okay, so that's as most important as an absolute fail-safe is everyone needs to be compliant by the 1st of July. Whether or not you have to have the pop-up banner is determined on the basis of whether or not you're processing that data from landing. And has that data subject at any other time been given the opportunity to see and accept your full privacy policy? Because if you think about it logically like that, you think, okay, Mr. John Smith just landed on my website. I've never engaged with them before, so they've never had an opportunity to see my privacy policy and understand how I'm processing. So if I am processing this stuff, I need to provide them with that pop-up banner, certainly. If you are not processing any technical information, then you do not need to have the banner. That is my determinative step. Rieka, any sort of insight on that?
Well, I can only add in that it doesn't have to be a cookie banner. It can be a privacy statement banner.
Absolutely.
So that you're drawing people's attention to the fact that you have recorded and they can see exactly where they're going and what information is being processed. And there you can include the cookie information into that statement. As per what I said, you can add it inside. So the banner will serve as a trust element rather than a blocker, if that makes sense. So from a South African law perspective, I don't think it's obligatory to have a cookie banner, but it is important to have the privacy statement and what you're actually doing with personal information easily accessible to the visitor of the site and to the customers of your service. So that includes not being, and we've been down this road before when you look at Consumer Protection Act and you look at, it's in clear, plain, understandable language, readily available on your website. And one of the best ways to show come the 1st of July is that a pop-up banner comes up and says, this is our privacy statement. And that's not bad.
Okay, I get it, and that sounds very reasonable and manageable. But this is yet again another thing to be added to our to-do list. Something that we've got to do. And Thomas, earlier you mentioned that the cops aren't kicking in on the door for people who aren't compliant. So I know some entrepreneurs might be, focusing on getting sales rather than being compliant and having all their ducks in a row behind the scenes. But what happens if a company is not compliant? If they just never do this, what's the worst that can happen?
Okay, Warrick, this is very, very important. And what I'm going to do is, I always say this, what is the motivation to comply? So number one, it's the law. Okay, so that's, guys, we're living in South Africa. It's the law of the land.
Great
we
argument.
Need to comply with the law. You pay taxes. What is it? Death and taxes. And now POPI. I love that. So certainly you need to comply with the law. What are the sanctions for non-compliance, guys? It can stretch all the way up to 10 years imprisonment. So please don't mess around. But I do want to assure you, they are not going to start with 10 years imprisonment. Okay, what will practically happen is that if you have been found to be infringing the act, first you're going to be approached by the regulator or your own data subject themselves, who will escalate it to the regulator, and they will start an investigation with you. Chances are it will then go to a compliance sanction. So they'll say to you, you must improve this, you must fix that, you must assure us A, B, and C. If you ignore them, which of course you must never do, if you ignore them, then you're going to start seeing the sanctions ramp up. And like I said, all the way to a 10-year prison sentence. So guys, please stay away from kind of upsetting the regulators to that degree. That's the law impetus. But like I mentioned in the beginning, guys, in South Africa, it's a self-regulation model. Very rarely are you actually going to be caught out unless your data subject reports you. Please don't take that as a reason to not comply. And that leads me into my next point, which is, well, what is the main reason to comply? Because of your need to remain valuable and attractive in people's data chains, like I mentioned earlier. If you are not compliant, you're going to start seeing your customers disappear. Not only because they don't trust you, which is quite common. Guys, I'm a savvy customer these days. When I go online, and I'm already in my 30s, you're going to be speaking to people in their teens and 20s who understand the value of data a lot more than we do. And they regard the protection of the data with fierce, fierce fire. And if you are coming across as a company that just disregards data and their assets, they're going to start disappearing. Okay, so it's about attracting your customers and then also making sure that you can receive and send data on a B2B and B2C scale. If you're not POPI compliant, like I said, you're going to start seeing your service providers leave. You're going to start seeing your partners leave. You're going to start seeing your contractors leave. And you're going to be left in wondering, why are you standing by yourself and no one wants to do business with you anymore? It's because you're not compliant and they are not allowed to do business with you unless you are showing POPI compliance or something of standard equal to or better. Okay, so number one, it's the law. But probably more practically focused for everyone on the call today is it's in order for you to stay viable and attractive to your market and other peers.
Okay,
I think
great. So
that I can add to that by saying that one of the parts of the law says that you must keep data up to date. So one of the issues that we often get here in South Africa is that you get emails sent to you about products that you bought ages ago and you finished with that product. Cars are a very bad example. So Garage will send you all sorts of emails saying, this is new car or whatever it is. You're not interested, you've got something else. You must keep your data up to date. And that's good business practice as well. So we come back to this thing of good business practice, but that will be the sort of thing I think that the regulator, who we really just introduced into this conversation, will pick up first, because you'll get people complaining. Oh, I asked to be opted out of something and they keep on sending me data, emails, and I don't want it. So I think that's the sort of thing that will happen. Sorry.
No problem.
And I think
that's
there,
good.
it's very important that you, in your privacy statement, and you start to educate your visitors and your customers what rights they have. So you must actually say that you have the right to opt out of certain information, you can delete certain information, you have the right to access to certain information, so you're transparent. So that's a critical component of your privacy statement that also enables them to approach you as the e-commerce provider, that you can then resolve the issue before it has to escalate to the information regulator or to a complaints process. So you get that in place, and then the relationship as well. If you respond to those requests timelessly, the relationship with your customer is actually improved, because then they feel comforted by getting a timeless response.
Absolutely. And Rieka, what about the situation where you don't control the whole information chain? For instance, if an e-commerce store has also got their products replicated onto Instagram and Facebook, or if you are selling through the Takealot marketplace or Bid or Buy or any other marketplace where your customers are giving information there, but the information is being passed over to you, do you need to control that? And what do we need to know about that side of the thing, side of operations?
I think that's a very good question, and it's a very difficult one, because it does add extra work to go through the chain and to find out who is a responsible party in that particular scenario, and then to tell the responsible party that I've received this data subject request, please can you action it on your side. So it ties to what Thomas was saying earlier about the data chain. You have to have those contracts and that alignment so that you can reach out and make sure that that response is then being met. And there, a good internal practical policy to have in place is your process of how you're going to respond to data subject requests. Do I have the contact details of all the vendors and the multiple, can I have access to the databases where I'm keeping this information, the multiple ones? What about my, I don't know, my get response or my little tool? Do I know what's in there? And can I make sure that within a time frame, I can actually delete that?
Right.
Warrick,
I think there's so much more that we could ask on this and talk about this. But,
yes, it's a full hour on its own, or maybe a day.
Absolutely. But let's go to kind of closing thoughts, and we might have to have many more conversations on this topic. But just in terms of wrapping up our conversation today, Thomas, what closing thoughts do you have for us?
Guys, my closing thought is we're at almost an epoch. It's a change. It's a massive change in the law in South Africa. When the Consumer Protection Act came out, it changed the way that people sell things in the country, and we all took it very seriously. When the New Companies Act came out, we all had to restructure things, and we had to sign this and delegate that and nominate this and be subject to a whole bunch of laws. We took those seriously. We are working with them seriously, and there's a major benefit. We are now at this juncture when it comes to data. We look around the world, we see the value as well as the risk posed by the proliferation and use of data. So it's undeniable that it is a very valuable asset that is now recognized as being the property of the data subject. Gone are the days where I own someone else's data. No, it's an asset like someone else's. I'm taking it for a particular purpose and time, and then I delete it or give it back. That mindset shift is a massive paradigm through which we have to look at everything to do with data going forward. This isn't simply, oh, I need to add a little this or I need to add a little that. You literally need to change the way you deal with data entirely, and not just the person sitting at the top of your e-commerce store as you, the CEO. I'm talking everybody at your company, from the receptionist answering the phones to the cleaners helping you out on the weekends. Everyone who has access or touches data at your company has a shared responsibility. And it's time now for everyone in South Africa, and all of you guys and all the stores, to take on the responsibility properly, because there is major benefit to doing it properly.
Absolutely.
Yes, Thomas,
well
and
Rieka,
I would
yes,
love to add this comment that I read quite recently, and it's basically that you can add data protection and privacy in along with saying that trust is a new currency. So trust is the element that will enable you to continue to scale and to grow your business.
Absolutely. And, from an e-commerce point of view, trust is what gets us sales. Somebody could come to your site, you've done all the marketing right, you've designed your website to look beautiful. You've got your products, you've got your pricing, they look at a product, they want to buy it from you. But if they look at your site and they don't trust that site, they are not going to put their credit card details into your website. And this right here, what we're talking about today, is a crucial part of building that trust. So we need to get it right. And I'm glad that this conversation has been had, and we might have to have many more. But Alastair, thanks for organizing today. What's some closing thoughts from the e-commerce forum of South Africa?
Well, I'd like to thank all these people. We are still virtual for the moment, but one day we will actually sit around a fireside. Meanwhile, we will, as you suggested, drill down into the issues which are raised by the POPI legislation. It is a complex law. Thomas said it's easy to read, but it is a complex law. And there will be a lot of interpretations made over time by the regulator, and the regulator is very important within this. It's a five-person organization, which is key to the moving forward of the legislation over the next years to come. And we will have to watch very carefully what they say. They will be issuing guidelines over time as well, so we will approach those as it comes along. But watch this space, please. Thank you very much indeed for watching us. Like us and follow us on Facebook too. We look forward to engaging with you all in the future. This is the future of e-commerce. We mustn't muck it up. Thank you very much indeed, everyone. Thank you, all the speakers.
Thanks
for having us.
Bye, guys.